whether it's ended by virtue of termination or however it's characterized, it just gives you the two hash marks of when he started, now when he finished.
Let me interpret this in a legal statement. What about that? That's saying that Mr. Chauvin started on this date and ended his employment with Minneapolis on that date. Not terminated, ended his employment. Would the defense have a problem with that? Because I think that is relevant. Because that does not imply an opinion by the city of Minneapolis, although it may have been stated publicly, that would come in this case. And that's my concern, because in a normal case, we wouldn't even get close to talking about whether a person's still employed by their victim employer. So why, I guess, that's what I'm throwing out. I think I am going to rule in that manner, which is the state can bring out the dates of employment, and he is no longer employed by Minneapolis Police Department.
Thank you, Judge.
We avoid all this problem of why did Judge or Chief Arredondo terminate, all that kind of stuff. And it's very limited probative value, but I think you get it with what I have now stated the state will be allowed to do. Mm-hmm. Any questions about the limits on that?
Nope, understood, Your Honor.
All right, thank you. Do we have any other motions for this morning before we start jury selection? Or any updates from the Court of Appeals? As Mr. Frank checks his phone. Yeah, you can all check your phones if you'd like, just to see where we're at.
So that right there was court earlier this morning. At 8 a.m., lawyers got in and started filing motions, and then you heard right there, Judge Cahill says, all right, have we heard from the Court of Appeals yet? Have we heard if they've made any kind of decision on if we can move forward with jury selection or not? Literally at that moment, he makes a joke that one of the prosecutors checks their phone to see if they have an update. That is just how moment to moment this is. Yesterday, Judge Cahill gave prosecutors a day to reach out to this appellate court to see if they had any input on if this case should move forward with jury selection while that third-degree murder charge is still hanging in the balance. He said as long as they said that they couldn't move forward, he's going to move forward. So a lack of an answer from the Court of Appeals means that Judge Cahill wants to move forward with jury selection. He says he's going to do that here at 9 o'clock this morning. Just so you're prepared for what you're going to see on the live stream, we're told that during this jury selection process, we'll be able to see the judge and we'll be able to see the lawyers, but we will not be able to see the prospective jurors as a protection of their privacy. We're also told that these prospective jurors are going to be brought into the courtroom one at a time, and at that point, that's where they will face some questions from prosecutors, from the defense attorneys, even from the judge in some cases. These potential jurors that are coming in this morning have already filled out a 16-page questionnaire, kind of trying to learn more about their background. Of course, lawyers are trying to find an impartial jury here in Hennepin County, people who haven't already made their mind up about this case. So it sounds like that process is going to get started here within the next 7 minutes or so, unless during this recess the Court of Appeals has gotten back to the court. But again, this morning you just saw it. Judge Cahill asked if anyone had heard back. Lawyers are literally checking their phones in real time to see if they had gotten any sort of decision from the Court of Appeals. So we're about 6 or 7 minutes away from when court is scheduled to be back in session for the jury selection to begin, a process that was supposed to start yesterday, likely going to start here at 9 o'clock this morning. So for now, we'll take you live into the courtroom, and we'll be sure to keep you updated as soon as that process begins. Yes, let's open my mic. Now, as we wait here for Judge Cahill, for defense and prosecution to come back into the courtroom to start this jury selection process, we're going to show you an interview that I did last week with a local defense attorney talking about how this process is going to work. Again, this is the first time in Minnesota state history that we've had a case air on television like this. So for a lot of us, we're learning about this whole process for the first time. So I was able to talk to this defense attorney, Lee Hutton, who broke down for me what we can expect during this process.
Lee Hutton from Hutton Magic Law Firm is joining us today. Lee, thank you for being with us.
Well, thank you for having me.
Let's dive right in. I want to just talk about right off the bat, how does the jury selection process begin?
So first off, to start, many individuals mistake, and even lawyers mistake, when trial actually starts. This is when trial begins. The selection process is probably the most important piece of any trial, because these are going to be the individuals that ultimately decide the fate of adjudication in this case.
How does the process begin? Where do we find our first pool of jurors that will start this questioning process?
Yes, so several months before the trial started, individuals received a little envelope in their mailbox that says, "We're inviting you to be a juror on the case." And they don't know which case. And so there's a random selection of many individuals who are just sitting in a random room. And when their name is called, they go into the fateful doors of the courtroom and they'll pull the first 12. Attorneys will get to ask questions. They'll get to determine which ones will be stricken. And then the ones that are stricken, they'll just be replaced until they get a nice set of 12 individuals who are the final jurors.
What kind of questions will these potential jurors be asked by the lawyers?
Well, most importantly, the lawyers will ask questions that will try to establish goals. So basically, they'll try to sell themselves to the jury, the attorney. Are they liking the attorney? Have you recognized anybody on the defense side or on the prosecution side by name? Obviously, everyone knows Keith Ellison. The defense counsel has some very prestigious attorneys as well. So they'll ask questions to determine if there's a special relationship. Now, the next thing that they're going to do is they're going to try to set other primary goals, which basically the goal of winning the case. Now, the mistake is that lawyers cannot argue their case in voir dire when they're asking questions. But you'll see that the lawyers will say, this case is or was about X. Do you have the ability to forget everything that you say or that you learned in the past? Most importantly, people ask me what I do for a living. They naturally want to hear that I'm an attorney, but quite frankly, I'm a cultural anthropologist. And the questions that are going to be asked is to get at what is the American anthropology of what people understand, because this issue is going to be about race. You're going to hear questions about race. You're going to hear questions about economics. You're going to hear a question about, have you been through the criminal system? And if so, would you hold somebody accountable if they had some past transgressions?
You brought up the word voir dire, which is something that we're going to be hearing a lot. Can you explain that word and what it means in this context?
That's right. Yeah, it's one of those fancy lawyer terms that lawyers often learn Latin. So it's Latin term that's based on the questioning of individuals, kind of a preliminary question. And voir dire may not just be the attorneys. The judge, you'll see, will ask questions to the jurors as well. And the voir dire process even starts with the questionnaire where they fill out their demographics, their psychographics, and that information is given to the attorneys.
Sure. So that questioning begins. We're learning about the jurors, how impartial they can be in this case. You mentioned strickning jury members. What does that process look like? What kind of tools do the attorneys have to shape this jury?
That's That's exactly right. Let's just take a question about race. A question of asking the jurors, have you ever used a racial derogatory term historically? And if a juror says, yes, I have, answering it honestly, that may be cause for them to strike this case because of some impartial or biasness. There may be another cause to strike a juror because they may have met one of the defendants that are part of the trial, Chauvin, or maybe have met George Floyd, who is the center of the prosecution's pursuit of action here. So those are reasons for striking a juror, and that can be done what we call for cause, where there's no debate, they're off the jury, and they basically just replace it with another jury.
How many of those strikes does each attorney get?
That's a great question. So the defense gets 15 and the prosecution gets 9. This is going to be a large jury pool. Obviously, jury selections is going to take 2 weeks, and that's not uncommon for a case of this profile.
What are the defense and the prosecutors, what are their goals going to be in shaping this jury? What are they going to be looking for? What are they going to be tossing out when it comes to getting these 12 impartial people?
Exactly. In a perfect world, most attorneys will tell you that we want 12 individuals who know nothing about the case. That is going to be impossible here, especially with the level of technology that we have compared to 1994 with OJ, and prior to that, around that area with Rodney King. What they're going to be looking for, quite frankly and candidly, is jurors that will understand their position, understand from the prosecution side that their theme is going to be enough is enough with police brutality. Do you know, and do you agree, and are you fed up with the history of those issues within the city and across America? The defense is going to be looking at, are you able to set aside your own personal differences of when you got the speeding ticket?
All right, so court is back in session. Judge Cahill just got back up to the podium, so we're going to hear from him.
That are available. My name is Pete Cahill, and I am one of the judges of the district court, and you have been summoned as potential jurors in the case of State of Minnesota versus Derek Chauvin, which is a criminal case related to the death of George Floyd on May 25th, 2020. A person charged with a crime has a right to a fair trial before a fair judge, an impartial judge, and a fair and impartial jury. In order to make sure that the jurors who are selected are impartial, the law provides that the court and the attorneys may ask questions to all prospective jurors, which must be answered under oath. And first, thank you for filling out the questionnaire that was mailed to you and returning it. Your contribution to the important and serious matter at hand is best assured by continuing to provide full and complete answers to the questions that you will be asked today. These questions will follow up on issues from the questionnaire and possibly other topics. Now, after the questioning is over, the attorneys will have the right to excuse some of you from service on this jury, and I may excuse others of you for what we call cause. In either case, it does not mean that you are not a fair person, and you should not take offense in being excused. I also ask that you not take any offense at any question you may be asked. We must pry, to some extent, in order to explore opinions that you hold and to hear about experience that you might have had that might affect your ability to serve in this case. The defendant, Mr. Chauvin, has been charged with murder in the second degree and manslaughter in the second degree. However, during trial, charges in the normal course might be added to or subtracted from these charges, but those are the charges as it stands. To the charges, the defendant has entered a plea of not guilty, which is a denial of each and every material allegation in the charges. And now I'm going to ask the participants to introduce themselves. In the individual questioning that follows, you will be asked if you know anyone here. So starting with the state, and you can remove your mask to be introduced.
Thank you, Rick. Would you like me to introduce the whole team? Or,
Everyone can introduce themselves. Mr. Nelson can introduce his client.
Thank you very much, Your Honor. Good morning, jurors. My name is Steve Slisher on behalf of the state of Minnesota.
Good morning, ladies and gentlemen. My name is Christina Marinakis, and I'm here assisting with the prosecution.
Good morning. My name is Matthew Frank. I'm Assistant Attorney General on behalf of the state.
Good morning. Keith Ellison on behalf of the state.
And for the defense.
Good morning, ladies and gentlemen. My name is Eric Nelson. I represent Mr. Derek Chauvin. This is my client, Mr. Derek Chauvin. Behind me is my assistant, Amy Voss.
Thank you.
Now, there may be other attorneys who are present for this case for the state, including Aaron Eldridge, Jerry Blackwell, and possibly other people who work for the Minnesota Attorney General's office. So, is there anyone on the panel, just by raising your hand, who knows somebody from the Minnesota Attorney General's office? Okay, no hands. Does anyone know Mr. Nelson or had any dealings with his office? Okay, no hands. And is anyone familiar with the defendant, Mr. Chauvin? Okay, no hands. You were given a long list of potential witnesses in this case, and hopefully you had a chance to review it sufficiently, because you'll be asked individually whether or not you know or are acquainted with any of those potential witnesses. Now, one of the things the attorneys may not do in jury selection is to instruct you on the law. But I do want you to be aware of some of the basic concepts that apply in all criminal cases so that you may keep them in mind as you answer the court's and the attorney's questions. I will instruct you as follows. First, the charges against the defendant are not evidence, and they create no inference of guilt. No member of the jury should in any way permit himself or herself to be prejudiced against the defendant because a charge has been made against him or because he has been placed on trial. The defendant is presumed innocent of the charges made against him, and in order for you to find the defendant guilty, the state must prove guilt beyond a reasonable doubt. The defendant does not have to prove his innocence. The presumption of innocence remains with the defendant throughout the trial unless and until he has been proven guilty beyond a reasonable doubt according to the law and the evidence admitted at trial. Proof beyond a reasonable doubt is such proof as ordinarily prudent persons would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. Now, if you serve on this jury, you and your fellow jurors will be the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect. But in determining believability and weight of testimony, jurors may take into consideration the witness's interest or lack of interest in the outcome of the case, the relationship to the parties, the ability and opportunity to know, remember, and relate the facts, their manner, their age and experience, their frankness and sincerity, or the lack thereof, reasonableness or the unreasonableness of their testimony in light of all the other evidence in the case, and any other factors that bear on believability and weight. If on this jury, you should rely in the last analysis upon your own experience, good judgment, and common sense. There are things you should not do, even during jury selection. You are not investigators. You are not to go out to do any looking, and you are not to ask people about this matter. You are not to use the internet to look for information about this case or about the law. Above all, you must not talk to anyone who is involved, the lawyers or the witnesses. Do not be offended if the attorneys, parties, or witnesses do not speak to you. They know that it would be improper to contact you, except through the normal selection process, and they will confine themselves to a brief greeting. Now, during the selection process, your family and friends will be curious as to what you are doing. You may tell them you are on a panel of potential jurors in a criminal case, and that is all you should tell them. And since that is all you should tell family and friends, that is all you should tell the general public. So during these proceedings, please refrain from using Facebook, Twitter, or other social media to announce that you are a potential juror or to comment on this trial. You may access such social media tools, but please do not publish any information about the case or your thoughts about the case. You do not have to stay away from people and refuse to speak to them. Do whatever you wish, but do not talk about the case, and do not talk to anyone involved. Because of the nature of the charges, this case will receive media coverage. Do not read about this case in the newspapers or online, and do not listen to news about it on radio or television. This trial, including jury selection, is being televised, but no video of you or any other juror will be taken at any time, now or during trial if you are selected. Also, your name will not be used in the courtroom. You will only be referred to by your random number. This is not a disrespect, it is to protect your privacy. The audio of anything you say will be broadcast unless we need to discuss something that is deeply personal or extremely sensitive or embarrassing, and I specifically order the audio not to be broadcast. In that case, you will still have to answer questions on the record, but without audio or video broadcast. Now, with the exception of juror number 1, we'll have you wait in another courtroom where you came from until it is your turn to be questioned. So you'll please go with my clerk who will escort you to that courtroom, whether you are in that courtroom or this courtroom. Keep in mind, although I took my mask off, it's only so I could be heard during now, and you'll see me put it back on for the remainder. But please keep your mask on and please follow social distancing. We also have hand sanitizer and wipes both available in this courtroom on the back table, but also in the courtroom in which you are waiting. And so with that, I'd ask you to go with the deputy, except for juror number 1. And juror number 1, we're going to have you come right up here. All right, be seated. Have a seat right there. Good morning. I'm going to have you pull that microphone up close to you.
Yeah.
Okay, we can hear you much better then.
Yeah.
All right, you're doing well, thank you.
Okay.
So first of all, I'm going to swear you in, so I'd ask you to raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I do.
All right, thank you. First of all, I think there was an indication that you had a concern you wanted to express to the court. Is that about a language or?
Yeah.
Could you tell me a little bit more about that?
Well, I'm not speak too much English.
Okay.
So, I don't know if I'm able to be here.
Well, let me talk about that a little bit.
Mm-hmm.
I read certain concepts of the law while you're sitting out there.
Mm-hmm.
Did you understand what I was saying?
I understand, but.
Okay, you said, but were there problems with some of the terms that I used?
Some words, but I understand.
Okay.
So.
Do you think that you, and I'm glad you brought this up, so I appreciate that. Do you think that this might be a problem for trial, that because we will have expert witnesses and a variety of people talking about different things, do you think that might be a problem absorbing everything and understanding all the evidence?
I understand, but the only I know what I see in the TV and, you know.
Okay. I guess what it comes down to is every juror should consider all the evidence. And if your language, speaking English, is good enough that you could understand it, that's great.
Oh, okay.
But also if you feel comfortable expressing your opinion in a jury room, that's also important. So, do you think basically what you've heard today from me in the instructions and in filling out your questionnaire that you understood the English language well enough to proceed as a possible juror?
Yeah, I understand.
Okay.
But
all right.
not like 100%.
All right. Thank you. All right. Well, let me turn to a couple of questions before I turn it over to the attorneys. First is, do you believe, now thinking back, you filled out the questionnaire, was everything on that true to the best of your knowledge? Like, is there anything you wanted to change or add to? Because sometimes people will fill out the questionnaire, and then they realize when they get here, oh, I should have probably said this or that, and that's normal. It's not like you're going to get into trouble because you give a different answer, because you are sworn under oath today. It's just a question of, is there anything you wanted to modify or add? Because maybe you had a thought since you filled out the questionnaire? Anything? Or is it pretty much accurate as it was?
Mm-hmm.
Pretty much accurate?
Yeah.
Yes? Okay. Now, the court has instructed you right from when you got the questionnaire not to read any articles or watch any media about that, and that was true when you got the questionnaire. Sometimes inadvertently, you might see a headline or someone might talk about it with you, maybe giving you something you didn't know about the case since you filled out your questionnaire. From the time you filled out your questionnaire and sent it in to today, is there anything you've learned about the case? And I'm not saying that you did so intentionally, but like I say, see a headline, hear some people talking, that gave you more information about the case. Do you think that that's happened?
Yeah.
Okay, what did you learn since you filled out the questionnaire?
The questionnaire when I don't know. I mean, because I had time to read and.
Okay, yeah. If you could slow down just a little bit. The court reporter is taking everything down, and I'm going to have you take off your mask just to make it a little more.
Mm-hmm.
That's great. So you read an article, or
Yeah.
Okay, what do you recall the article? What was the substance of it? What did it say? What information did it give you?
About the case for the George Floyd,
Okay.
how die, and I think it's doesn't fair because the guy he asking for he tell the guy I can breathe, so and he's still on top in her neck, So I think also the people who was with him, why don't say, hey, no, don't do that because you're gonna kill. So I think it's not good.
And is that something you read after you filled out the questionnaire?
Too many questions.
Or before?
Too many questions,
Yeah.
I read.
But this newspaper article where you got this information?
No, I send the TV.
Okay.
I'm working and I have to take care of my kids. I don't have too much time to be in those things. So just what I see in the TV, but
Okay.
I don't have time to read newspaper. Not just like what I saw in the TV.
All right.
So.
What it comes down to is it's just about everyone has seen or read something. The question becomes, can you put all that aside? Because as a jury, you have to decide the case just on the evidence you hear in the courtroom. Do you think you could do that?
I don't know. Like I said, I don't want to speak too much English. And
Okay.
I don't want to.
Okay. Did you recognize any of the witnesses?
On the TV?
Or on the list that we gave you?
Just one name right here is Korean. I don't know where he's from. I remember the TV, the name.
Okay.
Chinese or Korean, I don't know where he's from.
All right, and what was the name you remember?
It's right here. Sorry. Can find.
While you look for that, I'm going to talk to the attorneys so So you can keep looking, and I'm going to talk to the attorneys. Sidebar, please.
So, Tao Tu Tao.
Tu Tao? And do you actually know that person, or just?
No, just I saw on the TV.
Okay, just like what you've read in the media or something? All right. All right, what I'm going to do is I'm going to turn this over to Mr. Nelson, and he's going to ask you some questions. So if you could continue. Now, one of the things that happens when we're doing jury selection is, as everyone talks to each other, we sometimes get into a habit of being conversational, which is okay, but conversations that are informal, we talk over each other, we say or we need yes or no, and not to talk over each other. And the lawyers are just as guilty of it half the time, so about talking over each other. So I'll try and control that part, but make sure you try and wait for the question to be finished and then give the answer. Mr. Nelson, if you would.
Thank you, Your Honor.
And you can go to the podium.
Good morning, ma'am. How are you today?
Good, thanks.
So before I go too much further with my questioning, I just wanted to ask a couple of follow-up questions first on what the judge was asking you about. Would that be okay with you? Okay.
Yes.
Yes.
Okay. So just remember, we need to use words in the courtroom because everything is being typed down, okay?
Okay.
All right. Thank you very much for being here today. The judge asked you some questions. It's my understanding you indicated that you had a concern about your language.
Yes.
Can you say what it is more specifically, because you seem to be doing very well, answering our questions. What are your concerns about your language?
Well, I understand, but sometimes I afraid to say the wrong word, you know. But most of the time.
Most of the time you understand? Okay, that's good. In terms of this case and the testimony that you hear during the course of this case, you're going to hear testimony from a lot of different type of people, okay?
Okay.
So you may hear from police officers, and you may hear from citizen witnesses, people who saw what happened, but you may also hear from doctors, right? People who have used big words a lot. Would you be concerned about your ability to understand what a doctor or an expert witness might say?
Just a concern?
Concern.
No, I think
Okay.
I'm going to understand.
So if they're using medical terms, you'd be able to understand that?
I think so.
Okay, good. So your language, I think, is pretty good.
Okay.
Now, I just have so I'm going to ask you a series of just some general questions before I ask you some specific questions about what you wrote in your questionnaire, okay?
Okay.
So my understanding, ma'am, is that you received a notice from Hennepin County telling you that you were going to be a juror, or you could be a juror in a case, right?
Yeah, they sent me the questionnaire.
With the questionnaire? Okay. What was your first response to when you read that letter and the questionnaire?
My first, I say, why me? Because it's first time, and I don't know, you know. But I tried to fill out the questionnaire because I say I don't know if I had to be there or because it's first time and I'm working, you know.
Okay.
I had 3 kids, so I say I don't know if I'm gonna have time.
Okay.
But I'm gonna try.
Great. So your first thought was, if I understand you correctly, is why me, right? Is that a yes, ma'am?
Yes.
Okay, thank you. As you were filling out the questionnaire, and it was asking you specific questions about this case and your perceptions about this case, did it concern you more because of the nature of this case versus other cases?
Yeah.
How so?
I say that case just only I know because I saw on the TV, you know.
Right.
I wasn't there. And,
Okay.
So,
I understand you weren't there, but does the profile of this case concern you?
say again? Yeah.
So there are lots of, maybe I'll rephrase my question if that's okay. There are a lot of types of cases that come to court. Sometimes it may be someone steals something from a store, right? And nobody ever hears about it, right? But this case has been in the news a lot. You would agree with that? Is there anything about the fact?
Yeah, sorry, yes.
Sorry. Is there any? But this case has been in the news quite a bit, right?
Yes.
Have you only seen one news story, or have you seen many news stories?
No, like I said, I'm so busy at work, and you know, I'm housewife, and sometimes when I had time, I turn the TV and I saw, and most this case because just in the TV, you know, every day.
Every day.
Yeah.
And even since you filled out this questionnaire,
I had like they say, oh, why it has to do that, you know? I mean.
So let me, because you're saying something I think very important here, and I want to make sure I understand. Okay. you saw some videos about what happened. Is that correct?
Yeah, the news.
On the news? So you saw a video that many people have seen of the arrest of Mr. Floyd. Yes?
That's second wing.
So did you see a video of Mr. Floyd being arrested by the Minneapolis Police
Oh,
Department?
yes.
Yeah. And what I think you said is you had a reaction to that video. Would that be correct?
Yeah, I saw when that guy put his, I don't know, leg or knee on the, you know, so he can breathe.
Okay.
And he asking for.
And did you form an opinion about what you saw? That is that a
Yes, yes.
Thank you. I'm sorry, it's very awkward. It's not like real life. What was the opinion that you formed when you saw that video?
My opinion is when he tell the guy I can breathe, and he still do that, you know. And I remember when I saw another police around him, and I said, why don't say, hey, don't do that because he's gonna die. So I said, why? Just, you know, what I feel, that's not fair because we are humans, you know. And he